Hi everyone. I hope everyone is doing good. I just got home and I was watching Turtle Boys Bust Up from this morning. I He thinks this is a joke. He thinks it's a joke. But anyway, this is part two. Um, I searched, can a murder defendant be held liable for what a journalist publishes? Okay. Um, in US law, a murder defendant generally cannot be held criminally liable for what a journalist publishes because criminal liability requires the defendant to have committed the act or omission themselves. However, there are civil liability. Wait, I think I can use my glasses. Let's see if we can use mine. I want to fucking pivot on YouTube. Okay. Yeah. Let me see. Is this big enough? I can make it a little bigger. I'm fucking blind. I used to have like the best sight. Now I need like 1030s like Kev. All right. So criminal liability for defamation or related offenses requires the defendant to have directly committed the act, such as making a false statement themselves. A murder defendant is not criminally liable for a journalist's words unless they themselves authored or directly caused the publication. In most cases, journalists' reporting is protected under the First Amendment, which shields truthful or newsworthy reporting on matters of public concern. Civil liability. The defendant can't be criminally liable. They may face civil claims, which she is. If the journalist's publication harms their reputation and meets certain legal elements. Defamation. A claim requires that statement to be false. Truth is a strong defense, and protections apply to matters of legitimate public concern. Publication of private facts. If the journalist disclosed private, non public information not of legitimate public concern, and it was offensive to a reasonable person, the victim could sue for invasion of privacy. False light. If the publication places the defendant in a false light, causing harm, a claim may arise, though this is less common in murder reporting. Legal protection for journalists. Courts and states statutes generally protect journalists when they're reporting on matters of public interest, they're publishing information already in the public domain, using information from publicly available sources. These protections are designed to prevent a chilling effect or on free speech and to ensure the press can report on crimes without fear of prosecution for truthful reporting. But the digital media, okay. Practical takeaway. A murder defendant cannot be criminally liable for a journalist publication, but they could be subject. We already got okay. So here's university. Let me see. Systems. No, we don't want environmental. The fuck. Journalistic defenses. It's supposed to be S. And navigating legal publication of private facts. Oh, here we go. All right. I need some fucking water. All right, pause. I need something to drink. Here we go. Publication of private facts. In most states, you can be sued for publishing private facts about another person, even if those facts are true. The term private facts refers to information about someone's personal life that has not previously been revealed to the public, that is not of legitimate public concern, and the publication of which would be offensive to a reasonable person. For example, writing about a person's HIV status, sexual orientation, or financial troubles could lead to liability for publication of private facts. Excuse me. However, the law protects you when you publish information that is newsworthy, regardless of whether someone else would like you to keep that information private. In addition, the law protects you if you publish information already exposed to the public eye, and especially material obtained from publicly available court records. Despite the law's substantial protections for legitimate reporting on matters of public interest, it is a good practice to obtain consent before publishing sensitive private information about someone. Who can sue for publication of private facts? Only human beings. Duh. And not corporations or other organizations can sue for publication of private facts. Publication of private facts is a type of invasion of privacy, and you cannot invade the privacy of a dead person. Okay. Therefore, in a state, the fuck's this got to do with it? In a state took place before in question died. No, however. Okay, elements of a private facts claim. Plaintiff must establish 4 elements to hold someone liable for publication of private facts. Public disclosure. The disclosure of facts must be public. Another way of saying this is that the defendant must give publicity to the fact or facts in question. Private fact, the fact or facts disclosed must be private and not generally known. Offensive to a reasonable person. Publication of the private facts in question must be offensive to a reasonable person of ordinary sensibilities. Not newsworthy. The facts disclosed must not be newsworthy. Stated differently, the facts disclosed must not be a matter of legitimate public concern. And the thing is like it was all about him. Karen's not gonna get in trouble for what he wrote. It's fucked up. Think about that. It's like I get caught with 2 kilos in my car and I got my friend with me and I blame my friend. Or, you know what I mean? Like, okay, public disclosure, private fact. A plaintiff bringing a publication of private facts claim must show that the defendant disclosed the private fact. This means pretty much what it sounds like. A private fact is an intimate detail of someone's private life that is not generally known. Common examples of private facts include Common examples of private facts include information about medical conditions, sexual orientation and history, financial status. He's worried about what Karen's making. I mean, he sold out the will, but she's still living with her parents. you know. A plaintiff has no privacy interest with respect to a matter that is already public. Let's see, you cannot be held liable. Okay, a plaintiff has no privacy interest with respect to to a matter that is information about someone that is already publicly available, like found on the internet or a newspaper. Some example for something. And like this is the question is can a murder defendant be held liable for what a journalist publishes or says? That's what this is. Because I was sitting there thinking, I'm like, what? That shit don't sound right. How can you blame what you said and did on somebody else? There was intent there. And he thinks that the intent is going to assist him. The intent, I'm not even going to say it anymore. In addition, the murder defendant, cannot be held liable for giving publicity to a matter that the plaintiff leaves open to the public eye. For example, when the man who helped stop an assassination attempt on President Ford, he sued two separate newspapers for revealing that he was a homosexual. The court denied it, whatever. The records show that prior to publication in question, the plaintiff had frequented gay bars prior to publication in question. Okay, I don't give a fuck about that. All right. As the latter two cases suggest a person's photograph or image can be private fact, but generally not when it's captured in public or semi-public place. Therefore, you can generally publish photographs of an individual or individuals taken in public places without liability for publication of private facts. Publish a photograph of a couple kissing, this dude got whatever. Offensiveness. A plaintiff bringing a publication of private facts claim must show that under the circumstances, publishing the facts in question would have been highly offensive to a reasonable person of ordinary sensibilities. The question is whether the plaintiff himself or herself found the public disclosure highly offensive, but whether an ordinary person the question is not whether the plaintiff himself or herself found the public disclosure highly offensive, but whether an ordinary person reflecting community mores would find it so. Thus, the law does not give special solicitude to a plaintiff with thin skin, as the restatement of tort explains. Give me a minute. I went to Sandy Neck. I'm fucking thirsty as hell. Me and Mackie. All right. Let's see. This is what the restatement of torts excuse me, explains. Complete privacy does not exist in this world except in a desert. And anyone who is not a hermit must expect and endure the ordinary incidents of the community life of which he is a part. Thus, he must expect the more or less casual observation of his neighbors as to what he does, and that his comings and goings in his ordinary okay, uh, even minor and moderate annoyance, for an example, through public disclosure of the fact that the plaintiff has clumsily fallen downstairs. And what the fuck? I don't care. All right. Restatement. Second of torts. Hey, what are you guys doing? Okay, restatement of torts. Some examples of activities found to be highly offensive include publishing photographs of a woman nursing a child or posing nude in a bathtub. I'm sorry, I can't help but think of OGLG. No offense. No offense. I love you, girl. Displaying a movie of a woman's cesarean operation and disseminating a video showing two children, oh my God, two celebrities having sex. Some activities found not to be highly offensive include publishing an accurate account of a private, what the fuck, newsworthiness, matters of legitimate public concern, defining what is a matter of legitimate public interest can be tricky, but courts generally are reluctant to second guess the media. What? I'm just trying to say, what's a legitimate public interest in nearly all these events? That's about the guy that fell down the stairs. Despite the broad scope of potentially newsworthy topics, you risk losing your protection from liability if you exceed the bounds of common decency. The line is to be drawn when the publicity ceases to be giving of information to which the public is entitled and becomes a morbid and sensational prying into private lives for its own sake, with which a reasonable member of the public with decent standards would say that he had no concern. The courts agree that most facts about public officials and celebrities are of legitimate public concern, but they also recognize that even famous public figures retain a zone of privacy relating to things like sexual activity and medical information. Turtle Boy's fucked. She can't be held liable for that. Sorry, but I mean, I'm a genius. Duh. And then Aidan tried to add Alan Jackson and David Yannetti to the witness list. And I'm taking it off. I think I can see like this. Okay. And it just basically says that if hold on, let me find it. Where's the witness list? I just want to do this real quick, so I want to see like what it says about the lawyers. I'm telling Yannetti and these guys, he's his phones are what's gonna get his phones. I'll die on that hill. I mean, Dilla has been sending out shit. And Aidan completely avoids him. Okay, so it says here that he put Alan Jackson and David Yannetti. And this is what the court said. Please note that the defense was included following the defense was included the following names, which were included on the Commonwealth's prospective witness list: Alan Jackson, David Yannetti, and Elizabeth Little. The defendant agrees in the indication of the fuck indication. I'm not gonna. I can't. Okay. It's okay. So, he essentially wants them to testify for him. For what? He wants to be so involved in this case that he thinks he's going to get attorneys to testify for him. First of all, the rules of criminal procedure, like lawyers are fucked. Okay, so this request is not made in good faith. If the Commonwealth subpoenaed defense counsel in this case, it would constitute a gross violation of rules of professional conduct 3.8, which prohibits prosecutors from subpoenaing a lawyer in a criminal proceeding to present evidence about a past or present client, absent exceptional circumstances. Mackie Nani's over here talking to teaching these people what's really good. Telling them the truth, Mackie. That's what Nani's doing. You know me. All right. Let's see. It's got these things are like Bluetooth, and they got the microphone in it and all that. So they were expensive. They were JBLs, but they're awesome. All right. So despite the broad scope of potentially newsworthy topics, you risk losing your protection from liability if you exceed the bounds of common decency. The line is to be drawn when the publicity ceases to be the giving of information to which the public is entitled. Okay, I think we already went past that one. I don't think like they okay. Ordinary people may become involuntary public figures when they take part in an event or occurrence of public significance, such as a crime, accident, or spontaneous act of heroism. Hero. He thinks he's a hero. Many facts about like their home addresses and upbringing and family. The media is allowed to, what the fuck? The media is allowed to use colorful facts about newsworthy individuals to create a thorough and compelling portrayal, so long as there is some logical connection between the facts disclosed and the matter of legitimate public interest. Accordingly, a court has held that information about a physician's psychiatric history and marital life was substantially relevant to the newsworthy topic of policing failures in the medical profession. Yeah, talk about failures. Poor Lindsay Clancy. Accordingly, a court has held that information about connection between disclosed. All right, I want to do relying on public records. Recognizing absolute privilege for publication of information found in a publicly available, not sealed, court record, while the case involved traditional media. There is no reason to believe that its reasoning and holding would not extend to non-traditional journalists and other online publishers. This means that you cannot be held liable for publishing accurate facts about someone that you find in public court record, regardless of how embarrassing they are. Note, this privilege will protect you in publishing information about past crimes, so long as you gather your information from publicly available court records, such as an indictment or trial transcript. Publication of private consent. Turn the logo on. Mackie, honey's thirsty. Nani's thirsty. All right. Consent. Excuse me. Consent is a complete defense to a legal claim for publication of private facts. When you interview someone to gather information for later publication, it is a good practice to ask for consent to use the material on your website, blog, or other online platform. Make sure to get consent in writing whenever possible. You can use an interview release form. This release can help protect you against misappropriation and right of publicity claims, in addition to publication of private facts claims. You can find additional samples by doing basic common sense. What is it? Common sense investigator. That bitch is so stupid. I'm not. She ain't worth my time. Seriously, she's pathetic. Jess Machado is gonna come out of this. We're gonna all get together, and we're gonna pull through this, and we're gonna come up badass. Enterprise Portuguese YouTube channel. Fall River, or this release can help protect you. Okay. We already went that way. If you take photographs of someone for later publication, you should also consider getting a model release. It, protects you against claims of unlawful use of fame or likeness, but it also may be helpful if you photograph an individual in a private setting, or if restaurants should ban the use of cell phones unless the people taking pictures of each other. Taking pictures of other people with them not knowing and using it to mock them, that's illegal. And Karen didn't do it. Okay, children, we know they can't even. The statute of limitations is a term used by courts. All right, let's see. Subject, publication, state law. Okay. Let's see. Fair use. Lincoln to cops. Hold on. Legal guide homepage. I keep clicking this fucking. Okay. All right, no. We'll go to a disclaimer. Information in this guide is based on general principles of law, common sense, and is intended for information purposes only. We make no claim as to the comprehensiveness or accuracy of the information. It is not offered for the purpose of providing individualized legal advice. Use of this guide does not create an attorney-client or other relationship between the user and the digital media law project. Legal guide, let's see. All right, let's see risks associated with publication. Every time you publish something online, whether it's a news article, blog post, podcast, video, or even a user comment, you open yourself up to potential legal liability. This shouldn't come as too much of a surprise because the internet, after all, is available to anyone who wishes to connect to the network. And even if the smallest blog or most obscure discussion forum has the potential to reach hundreds of millions of people throughout the world. Often the legal risks are small, but not always. The risks you could face when you publish online can take a number of forms. Depending on what and how. I have like leftover freaking from, I don't know, when you put sunscreen on, like take a shot, it doesn't all come off. So it's like, I don't have herpes, I don't have giardia. Let's see. When you publish something that might result in liability, you will know to be extra careful and will take the necessary steps to minimize your potential legal risks. First, if you publish information that harms the reputation of another person, group, or organization, or inflicts emotional, we know what the false light, we know what all that. Let's see. If you publish private or personal information about someone without their permission, you potentially expose yourself to legal liability, even if your portrayal is factually accurate. For example, in most states, you can be sued for publishing private facts about another person, even if those facts are true. It's like, the public shouldn't care about that shit. If you use someone else's name, likeness, or other personal attributes without their permission for an exploitive purpose, you could also face liability for misappropriation or violation of the right of the right of publicity. Usually people run into trouble in this area when they use someone's name or photograph in a commercial setting, such as in advertising or other promotional activities. But some states also prohibit use of another person's identity for the user's own personal benefit. Whether or not the purpose is strictly commercial, they just publishing, okay, that, all right. If you have web forums, allow reader comments, host guest bloggers on your site, or if you repost information that you receive from RSS feeds. Section 230 of the Communications Decency Act will likely shield you from liability for certain kinds of problematic statements contained in these materials and any other user submitted content you publish on your site. You will not lose this immunity even if you moderate or edit this content, whether for accuracy or civility, so long as your edits do not substantially alter the meaning of the original statements. Keep in mind that CDA 230 will only protect you if a third party, not you or your employee or someone acting under your direction, post something on your blog or website. It does not shield you from liability for your own statements. Publishing the statements and the content of others. That's another one. Fourth, if you publish or use the creative work of others, their trademarks or certain confidential business information without the permission of the owner, you may be exposing yourself, to intellectual property law. It's if you allow your site's user to post this type of content, you can protect yourself from copyright infringement, which is now the Digital Millennium Copyright Act. Fifth, if you are a blogger or social media user who reviews or otherwise writes about products and services, the Federal Trade Commission has issued guides concerning the use of endorsement and testimonials in advertising. These guidelines require that you disclose material connections you may have with a company whose products or services you endorse. Without the legal jargon, this means that bloggers and social media users must disclose their relationship with a company when they are being paid or otherwise compensated by the company to comment favorably on its products or services. That's publishing product or service endorsement. Lastly, as you publish your work online, you may want to correct things you have previously published. Your willingness to fix past errors in your work will provide several benefits. If it will make your work more accurate and reliable, and then there's practical tips for handling requests to correct or remove shit. Like publishing information that harms another's reputation. But he did that to Karen. Publishing personal and private information. He did that to Karen. Publishing the statements and content of others. Did that to Karen. Correcting or retracting your work after publication. He did that to Karen. Publishing product or service endorsements. Dealing with foreign legal threats. I don't think he did that. Let's see. Publishing information that harms another person's reputation. I'll be right back. I gotta go pee. I'm back. All right. Publishing information that harms another's reputation. When you publish online, whether it's on a blog, in a podcast, in a video you upload to YouTube, or simply in a comment on another's website, you might say or do something that harms the reputation of another person, group, or organization. Fortunately, Not everything you publish that harms the reputation of others will open you up to legal liability. Simply state your opinion. Nevertheless, if you find yourself about to publish something that could harm another's reputation, you should spend some time familiarizing yourself with the various laws that protect reputation. The sections that follow are not intended to make you an expert on libel law, but merely to help you identify potential red flags so that when you publish something that might negatively impact the reputation of another person, group, or organization, you will know that you have to be extra careful. First, ask yourself whether what you intend to publish would upset you if someone else were to publish the information about you. This simple test won't tell for sure whether you will be liable if the information you publish turns out to be false, but it will get you focused on the statements that should have been whatever. Moreover, putting aside the legal implications of what you publish, statements that upset others, okay, depending on what you say and how you say it, you will likely need to be concerned with two different but related legal doctrines that aim to protect against reputational harm. Defamation, okay, we know that. False light, we know that. Paint someone in a bad picture. Keep in mind that the republication of someone else's words can itself be defamatory. Republication of someone else's words can itself be defamatory. In other words, you won't be immune simply because you are quoting another person making the defamatory statement. Even if you properly attribute the statement to its source. For example, if you quote a witness to a traffic accident who says the driver was drunk when he ran the red light, and it turns out the driver wasn't drunk and he had a green light, you can't hide behind the fact that you are merely republishing the witness statement. However, there is an important provision under Section 230 of the Communications and Decency Act. He published pictures of Paul O'Keefe. Those are the lewd and lascivious or whatever it is. And he published some other pictures of whatever too. As may protect you if third party, if someone acting under your direction posts something on your blog or website that is defamatory, publishing the statements and contents of others. There's so much like that. Karen can't get in trouble. So what should you do if you are facing the prospect of a lawsuit for defamation? First, familiarize yourself with this section on practical tips for avoiding liability associated with harms to reputation. Second, if you think you've been improperly sued in retaliation for your speaking out on a public issue or controversy, you may be able to get the case dismissed or file a counterclaim under your state's protecting against slap law, essentially. If you are sued in a state that has an anti-slap law, you may be able to end the lawsuit quickly and recover your costs. That's bullshit. Okay. Risks that associated with publication. Hold on. threats and risks. Um, okay, wait. Um, However, the publishing avoid liability. Hold on. No, everything we publish. Okay, here's one. Let me click on opinion. Opinion and fair comment privileges. The right to speak, guaranteed by the First Amendment to the U.S. Constitution, includes the right to voice opinions, criticize others, and comment on matters of public interest. It also protects the use of hyperbole and extreme statements when it is clear these are rhetorical ploys. Accordingly, you can safely state your opinion that others, state your opinion that others are inept, stupid, jerks, failures, etc. Even though these statements might hurt the subject's feelings or diminish their reputations, such terms represent what is called pure opinions because they can't be proven true or false. As a result, they cannot form the basis for a defamation claim. This is not to say that every statement of opinion is protected. If a statement implies some false underlying facts, it could be defamatory. For example, stating that, in my opinion, the mayor killed her husband is not likely to be a protected opinion. Couching false statements of fact as opinion or within quotes from other sources generally won't protect you either. Nor will trying to cover yourself by saying that a politician allegedly is a drug dealer, or that your neighbor said that the politician is a drug dealer, or that, in your opinion, a politician is a drug dealer. A reader may as well assume that you have unstated facts to base your conclusion on, and it would be a defamatory statement if the implied facts turn out to be false. And like I said before, no one's been charged with anything and no one's been convicted. So he's fucked. Like, he's fucked. I'm just trying to lay out the law so people know, there's certain things you can't do and certain things that you can't get away with. And one thing I'm not letting them get away with is what they're doing to Jessica Machado. The right to speak. The right to speak, guaranteed by the First Amendment to the U.S. Constitution, includes the right to voice opinions, criticize others, and comment on matters. Okay. No. Couch and false statements of fact that you, or within quotes from other sources, generally won't protect you either, nor will trying to cover yourself by saying that a politician is allegedly a drug dealer or that you're okay. Opinions. Compare the following two statements. During the last 6 months, I've seen Carol in her backyard 5 times at around 1:30 p.m. on a weekly basis. At 1:30 on a weekday, seated in in a deck chair. That's supposed to be on a deck chair with a beer in her hand. I think Carol must be an alcoholic. Well, I drank some Red Bull and Grey Goose today. I'm an alcoholic, I guess. And then the other statement is I think Carol must be an alcoholic. The first example states true, non-defamatory facts, upon which a reasonable conclusion that Carol is an alcoholic is based, and also emphasizes the limits of your knowledge, that you only saw Carol 5 times. It would be protected as a statement of opinion. Under the second example, readers would likely assume that there are unstated defamatory facts upon which your conclusion is based. Therefore, it would likely fall outside of the privilege. Distinguishing between statements of fact and opinion. Like, you can't be, I don't even know. These aren't for you, and stop humping your father. That's his dad, and he humps his dad. Hold on. This isn't for you. All right. Statements in the asshole of the month column in Hustler magazine that described a feminist leader as a pus bloated walking sphincter, wacko, and someone who suffers from bizarre paranoia were protected opinion, because the context of the magazine column made it clear that the statements were understood as ridicule or I'm not even try to say that word. Statements on a radio talk show that described a plaintiff as chicken butt, local loser, big skank. They weren't defamatory because they were too vague, apparently. All right. What did I ask? Oh, okay. Here we go. This is a good one. Federal shit. Don't mind me. I'm eating some lifesavers. I can't believe these bitches are back, like, prostituting Jess while she's on vacation. They think they can get away with it. You can't. What are you doing? All right. I'll read this. Just give me a second. How's everybody doing? There's too much drama going on. Moons, oceans, Jolene, Valhalla, Baker, the expert. All these people, they're just haters. That's all it is. No. I gotta get coffee in a minute. I have 1 minute. Oh, I just dropped one. All right. A journalist's guide to the federal courts. Federal judges and the journalists who cover them share an important goal. They want the public to receive accurate and understandable information about the federal courts and their work. The media performs an important and constitutionally protected role by informing and educating the public. The media also serve a time-honored role as the public's watchdog over government institutions, including the courts. Likewise, courts uphold many of the legal protections that enable journalists to perform their jobs. The guide is, the guide does not contain, okay, media recording, courthouse context. He used to get shit. Accessing court documents. Oh, I'm just looking and seeing what's the best thing for me to read. Helpful resources, media basics, accessing appellate courts, other judicial entities. We don't need that. Covering civil cases, covering criminal trial. Post-verdict interviews. Any media interviews must be arranged directly with lawyers and their clients. In high-profile cases, some type of media availability is common for prosecutors and defense lawyers in or near court property. Okay, non-capital sentencing, like that doesn't really make a difference. I'm just like trying to prove that like a journalist is not an activist. Can a journalist um what am I oh, all right. I asked, can a journalist be an activist? Sorry, but this looks a little crooked. Whatever, I give a fuck. The question of whether a journalist can also be an activist is a long-standing debate in media ethics with strong arguments on both sides. Traditional view: no, activism undermines impartiality. Many journalism organizations, such as the Radio, Television, Digital News Foundation, argue that political activity and active advocacy can undercut the real or perceived independence of journalists. The concern is that the personal activism can distort reporting, erode trust, and make audiences question the credibility of the outlet. Outlets like the Washington Post have strict ethics codes forbidding journalists from participating in partisan causes, political campaigns, or demonstrations that could seem to compromise fair reporting. This approach prioritizes perceived neutrality to maintain public trust. Some argue that the line between journalists and activists is artificial. In areas like human rights, environmental protection, public health, journalists may be inherently activists for freedom of expression or truth. Others suggest that advocacy based on truth and transparency can be legitimate and even necessary in a democracy, especially when silence enables harm. In contexts where journalists face repression, activism may be a survival and resistance strategy. He's fucked. Well, I'm just searching for something. I'm trying to find like the government. I should have it. Only way to lessen to divide and people show everyone that's the media. Okay. This form of journalism is on the rise. It's been called solutions journalism, activism journalism, and engagement journalism, and many other words, whatever you want to call it. It results in more impactful stories, more invested audiences, and better journalism for a better world. I wanna like ethics and shit, these folks. I have but you would think that he would um uh uh don't so don't make fun of me. You can say whatever you want about me. I don't know. I just drank whole milk, and you know what I did? I put ice in it, and it was so fucking good. Like, so good. Because you see, over in Portugal, in San Miguel, every morning there is a guy that comes around with his horses, um, delivering fresh milk. So, if that's a problem, you can fuck off. So I'm gonna say about that. Online safety and media records accountability, in which directly impacts journal privileges. Recent court decisions have reaffirmed the importance of this privilege. Okay. What do journalists need to know about the law? Karen isn't being, can there's no way. There's no way. Like, how you gonna try and charge somebody for what somebody else said. I mean, think about it. I sat here last night and I'm telling you, I was like thinking about it and thinking about it. And like, how the fuck can she be held liable if she wasn't the one publishing it? She wasn't the one doing anything. So she's gonna file a motion to dismiss hers, and hopefully they will. She wants nothing to do with Aidan. He basically just copies like whatever motion they write. He's a fucking loser. Um Publishing, negative, privacy, copyright. If you are a freelance journalist, you generally have rights to stories to publish unless you are working under an agreement that says otherwise. Obtaining information from the government, police conduct. Journalists often face situations where they interact with the police or other law enforcement. Let's go to blogger, because that's what it is. The blogger. I'm just trying to like read what's important because I think I've explained it well enough to you that what she can't be held liable. You can't now. He's trying to blame her. He's saying, "Oh, she made me do it." But she didn't do it. Like she didn't physically do anything. He was the one doing it all, and he's to be held by certain ethical standards. How's that our fault? I don't think I'm gonna really say too much about it because I think I've explained myself well enough. But um the Lindsay Clancy case sketch, why didn't they investigate Patrick? That's what I want to know. Give me that answer. Let's see, what do I got here? That's good. Um, this is the I'm reading some. It's like the Sandra Birchmore. I mean Sandra Birchmore. Karen suing MSP. Like this is a sick one. I hate it. I hate it. Makes me sick. All right, there's other shit that I wanted to um talk about. What's GSE? Karen Reed motion to dismiss. Um, check my downloads. Don't mind me. I'm stoned. A good weed. I've got some good weed. Grant would love it. All right. Where the fuck is my shit? I'm an idiot. Don't mind me. Gen 2 some files. I don't want those. That's Uvalde. That's too much. All right. All right. So I'm just gonna go over Lindsay Clancy's. It's the warrant or whatever. But there's some shit that don't make sense. All right. I'm just like, Mr. Clinton. Because I'm thinking of the time. The time because he left, went to that place, and then the CVS, which is like really close. How could she have had time? I don't know. I gotta look into this. I just don't want to read shit about. I'm looking to see like what they never questioned Patrick. He was never investigated. He automatically just said she effing killed the kids. Like that's what he said. All right, here it is. The video shows Patrick Clancy enter 3V through the front door at 17:54 hours. What's that? So 12 then 13 is 1, 14 is 2, 15 is 3. So 5. Around 5:54. Patrick Clancy glances at the takeout table, then waits in line behind a couple for a brief moment. While waiting, he looks at his cell phone. After the couple leaves, he approaches the hostess desk to pick up his order. He pays for the order at 17:55. Um, Video shows Patrick enter the CVS through the front door at 17:32 hours. So what was the other one? What was the other time? 17:54, I think. I'm probably really bored. But like their relationship was not perfect. And I think the fact that they aren't even looking into it is it's fucking gross. Let's see. Can he reply to oh, is this the better? Oh shit. When was this filed? 7/10/26. He always puts like Karen Reed and Aidan Kearney. The judge already said, like, it's got nothing to do with it. He does not want to hear it. Don't mind me if I eat some lifesavers. I'm just in shock. Like his lawyers know he's going to jail. They have to. There's no way. my God, this is gonna be a really funny motion. I'm gonna go and smoke a joint. And I'll be back. See, that's what I like about recording. Like, I can stop when I want to stop. You know, let the dogs out when I want. Oh, whatever. But I'll go live once I have more followers, and of course, we gotta like talk some shit, but then we get down to like the real shit, like things that need Enrique. Like, we gotta start getting on that case once it gets going. Deanna Cremens. Like, I'm trying to get the Suffolk DA to test 3 samples. I think her boyfriend, much older boyfriend, did it. That's my opinion. Allegedly. All right. Plaintiff's opposition improperly focuses on allegations that are not relevant to the discrete causes of action against Kearney. To determine whether a claim is based on petitioning activity alone, the courts may consider only the allegations that are relevant to the discrete causes of action. Courts must separately analyze the allegations relevant to each challenged cause of action and determine on a claim-by-claim basis whether each such claim has a substantial basis other than or in addition to petitioning activity. To survive this first stage, the proponent must show that the challenged count has no substantial basis in conduct other than or in addition to the special motion proponent's alleged petitioning activities. All right, I'm gonna take a little break. I'll be back. So this one was part 2. Yeah, this is long. There's a lot. Like, I hope that I kind of cleared some shit up for you guys. And you guys learned about it, and I mean, I can't believe it. Like, no one's ever thought about that. Like, all right, I'll be back in a little bit, a few minutes. There we go. All right. The plaintiffs take the extreme position that spewing defamatory words to the general public can never qualify as petitioning activity, or else the tort of defamation per se will lose all the meaning. The law, however, has long been to the contrary. Let's see, in noting in action involving alleged libel, published on a website accessible to the general public, that it has been firmly established that the anti-SLAPP statute is applicable to defamation actions. Indeed, the SJC has described a special motion under 59H as strong medicine, precisely because it offers a party the prospect of having the claims filed against it dismissed, regardless of the merits of those claims, under a very, very favorable statutory standard. Presumptive entitlement to dismissal, unless the opposing party can prove a negative. In other words, even assuming that plaintiffs can prove every element of the defamation and other torts. They assert by a preponderance of the evidence. The anti-SLAPP law still requires dismissal if the claims are solely based on petitioning activity and the petitioning activity was not devoid of any factual or legal support. Kearney petitioned on his own behalf as an activist and a citizen. My hair. I gotta get that stupid, like, I don't know, whatever. Plaintiffs next rely heavily on Fastillo. Again, that's a law that, they use. Okay, so I want to make sure it was recording. Let's see, sketch it. Here, of course, Kearney did not purport to be a neutral news reporter. From the start, he argued that Karen Reed was innocent, that plaintiffs were guilty of the whatever, and the police investigators were corrupt. Accordingly, this case is governed by Cardinal Camera, where activists were sued for publishing an article about a pollution case in which they were not directly involved. Referring to Fastillo and other cases, finding that a moving party was not exercising its own right of petition, the SJC noted that none of them involved speaking out either on their own behalf or based on their status as a citizen. The special movements in those cases spoke in the capacity of either a contracted government witness, a government employee, or a journalist charged with objectively reporting the news, and thus were not speaking for themselves. The SJC went on to reject the idea that petitioning activity must be limited to advocacy in one's own self-interest. His self-interest was Karen and money. Indeed, in direct conflict with their position that Kearney was not exercising his own right to petition, plaintiffs concede, as they must, that generally raising awareness about potential corruption in a police force can qualify as protected petitioning activity. That, of course, is exactly what Kearney was doing when he accused Trooper Michael Proctor and other public officials of a corrupt failure to investigate the plaintiffs for the killing of Officer John O'Keefe, despite the substantial evidence pointing to their guilt. His very first Canton cover-up post, after all, is headlined, "Corrupt State Trooper Helps Boston Cop Cover Up Murder of a Fellow Officer." Plaintiffs misrepresent the SJC's holding and whatever. To try to satisfy, to try to satisfy his burden of establishing that Kearney's petitioning was devoid of factual support or a basis in law. Plaintiffs submit affidavits to try to rebut the factual assertion in Kearney's motion, a tactic that is wholly insufficient under the SJC. Plaintiffs cannot prevail merely by submitting affidavits controverting the statements made in defendant's petitioning and in the affidavits supporting defendant's special motion to dismiss. I just trying to see what's good. There were two instances of challenged petitioning in that case: a police report and an application for a criminal complaint for trespass, neither of which led to charges. As for the application for criminal complaint, the fact it was dismissed for lack of whatever. Conclusion: for the foregoing reasons and the reasons set forth in his memorandum of law, Kearney respectfully requests that the court allow his special motion to dismiss. Respectfully submitted. He's got his 3 attorneys. All right. Jennifer McCabe, whatever, versus Karen Reed and Aidan Kearney. Defendant Aidan Kearney's reply in support of a special motion to dismiss plaintiff's first amended complaint pursuant to the anti-SLAPP law. It's fucked. Like, I mean, think about it. You can't, like, here it is. It says Kearney petitioned on his own behalf as an activist and as a citizen. And think about it. That is exactly what he did. It's exactly what he did. Here, of course, Kearney did not purport to be a neutral news reporter. From the start, he argued that Karen Reed was innocent and that the we all know that. Indeed, in direct conflict with their position that Kearney was not exercising his own right to petition. Plaintiffs concede, as they must, that generally raising awareness about potential corruption in a police force can qualify as protected petitioning activity. That's not what he was doing. He was petitioning and harassing private citizens. Private citizens can't make change. Plaintiffs misrepresent the SJK. He wants this dismissed too. Same thing. Then this one is again, defendant Aidan Kearney reply. Plaintiff's amended complaint includes 5 causes of action against Kearney: defamation, intentional infliction of emotional distress, negligent infliction of emotional distress, civil conspiracy, and violations of General Law 93. That's violation of civil rights. He's fucked. Hang on. Yeah, like calling people these names and stuff, like that's not petitioning activity. Like, and I don't know what part of this that these people don't understand. Like, Karen is not getting in trouble for this. She's appealing the judge's decision, and I think she's gonna win. But she needs to do it alone. She needs to separate herself from this fucking prick. Plaintiffs next rely heavily and Fustello to argue that Kearney is not entitled to the protection of the anti-SLAPP law because he was allegedly acting on behalf of Karen Reed rather than his own behalf. Here, of course, Kearney did not purport to be a neutral news reporter. From the start, he argued that Karen Read was innocent. The plaintiffs were guilty of the murder and that the police investigators were corrupt. Like, hold on. Like, he tries to add Michael Proctor in here too. To try to satisfy their burden of establishing that Kearney's petitioning was devoid of factual support or a basis in law. Plaintiffs submit affidavits to try to rebut the factual assertions in Kearney's motion, a tactic that is wholly insufficient under SJC precedent. Again, he asks for it to be dismissed. Then this one's the same thing. It's like the same exact, it's all boilerplate. Just like he said. He even said it himself. I'm a lawyer now. You know? I can do this, I can do that. AK motion redacted. This is freaking Bettero. Like, seriously? This guy, he's a Twitter lawyer. Like, who does he gets paid to like go on Twitter all day? Let me see if there's anything good we can talk about. But like I said, all these people just piling on Jess. Like, I don't know what they're thinking, but it's not gonna work. We're coming back like a typhoon. We got her back. We got the right people in our corner. So, and I think you guys know that. And you're scared. State the court finds in this case. That's like nothing. Yeah, but like I said, I'm gonna there's more like that I want to say. Like, every time he has a show, like, of course I have an opinion just like everybody else. But I just also wanted to say that Scotty or whatever, I think he's mad cool. I loved his t-shirt. I wore my Trump shirt purposely. And yeah, that's that. Alex Jones, he's fucked. Let me see. Bridgman, supplemental, Rosie Graham, drug. Okay, yeah, like I have. All right. This one is Commonwealth versus Sergeant Jennifer Penton, Trooper Edwin Rodriguez. I think he's the one that he's a boxer. He won like so many fights. Dude's no joke. This is just all about they want all the discovery, but now the Penton and whatever are trying to say that the investigation was like fucked. Of course it was. Ryan, I don't know what that one is. I never like put down like Eddie O'Brien. I wonder how he's doing. I gotta check with him. Affidavit of Aidan Kearney. Which one is this? He wants people to talk about his shit, so I'll talk about it, I guess. This thing is 65 pages fucking long. This is unbelievable. This is for the day that he went to court. I can't believe he spent all. How long did it take to like do that? To do like exhibit 1 to use my computer. How would that work? Look, I told you I'm sorry. I know you're upset, but I've never done any like. And then he refers to like one of Lana's videos and says that it was Meredith's, but it wasn't. Oh, Lindsay Clancy's. Like, this is fucked up. And I guess she signed an NDA, but it doesn't matter. The Commonwealth will take it over. Hold on. Answer to a complaint denied. The statements are not false. They are based on the defendant's experiences and reports to law enforcement, including allegations of criminal conduct, sexual assault, witness intimidation, illegal interception of oral communication, and violations of a restraining order, and observations of the plaintiff's behavior suggestive of substance abuse or mental health abuse. Any such statements were made without malice and in good faith. Furthermore, Kearney has made multiple public statements about his mental health conditions, e.g., depression, anxiety, and Kearney has publicly admitted to threatening suicide. The statements were not made with actual malice or reckless disregard for the truth. They were based on the defendant's personal knowledge and belief in their truth. Count 1, slander. She basically, the same thing, but he's still messing with her. The defendant's conduct was neither intentional to cause distress nor extreme and outrageous. It was responsive to the plaintiff's own extreme actions, including alleged sexual assault, threats, harassment, and public defamation of the defendant. Gatuni's public statements were also made due to the negligence per se of state officials who disclosed the great report in violation of law and their duty to Gatuni. And because those officials failed to take action, this is Gatani's public statements were also made due to the negligence per se of state officials. This was Gatani commenting on a matter of public concern. Indeed, on the same night, January 7, 2025, that restraining order held by Gatuni was not renewed. Kearney went on social media live show and brought up the sex assault allegations. In question, prior to Gatuni discussing the assault in public, Kearney joked with other members of the social media show about the quality of the sex with Gatuni during the sexual assault. At another point in time, during a public broadcast, Kearney also joked gleefully about how Gatani refused to give him a roadhead on the night of the sexual assault and attempted to flee Kearney's vehicle during that portion of the sexual assault. Okay. So, actual malice not proven. Unclean hands. Any alleged losses or harm suffered by Kearney, including reputational or counterclaim. Imagine waking up like every single day, going on Twitter to see what people are saying about you, and then lose your shit and blame other people. It's not going to work. It's not going to work. And then he talks about broils. Gatuni asserts that the governmental counter defendants, Haldeman, that's that cop, Aidan's boys with that dude. Hang on. There's things that she said, yeah. While driving. Okay, wait a minute. Facts common to all counts. On October 14th, 2023, Kearney sexually assaulted Gatuni. The assault began at McMorgan's bar in Norwood, where Kearney engaged in non-consensual sexual contact in a public area. While driving Gatuni from the bar to her home in Medfield, Kearney attempted to elicit Gatuni to perform oral sex on him. Roadhead. Gatani fled Kearney's vehicle on an active roadway to avoid doing so, whereupon two passerbys intervened and attempted to rescue her. Kearney then prevented those two passing motorists from assisting Gatuni. He forced Gatuni back into his car and then transported her to her apartment, where he engaged in further non-consensual sexual intercourse with Gatuni, who, while she was impaired and unable to consent. Kearney recorded the encounter without Gatuni's knowledge or consent at the time. Kearney's actions during the drive, preventing rescue and forcing Gatuni back into the vehicle, constituted false imprisonment, as Gatuni was confined against her will without legal justification, causing her fear, humiliation, and physical restraint. And then she suffered, okay, on December 22nd, 2023, Kearney was invited to Gatuni's home. After Gatuni received that grand jury subpoena related to Kearney and Karen Reed, Kearney declined that invitation. During that day and into the morning of December 23rd, 2023, Kearney began a series of harassing communications towards Gatuni. Kearney sent Gatuni highly sensitive judicial documents and made other implied threats until Gatuni provided information to Kearney. Then Kearney told Gatuni he would visit her the next day, December 23rd. On the morning of December 23rd, Kearney asked Gatuni to install the Signal Messenger app. Kearney, after those series of messages and attempts at coercive control, appeared at Gatuni's home, demanded to see her phone, threatened retaliation if she testified before the grand jury, or refused to comply with Kearney's demands. He took notes from her phone, wrestled her for the notes, and pushed her onto a couch. During this exchange, Kearney told Gatuni that she could legally delete all information on her phone because no preservation order had yet been served by prosecutors on Gatuni. When Gatuni asked Kearney what she should do at the grand jury if asked about the deleted information, Kearney told Gatuni to say she did not remember when asked those questions. Kearney then offered Gatuni a lawyer and said he would be willing to pay for it to help Gatuni. However, in the same breath, Kearney informed Gatuni that he could not trust her any longer, and in turn, Gatuni would only be permitted to meet with that lawyer with Kearney present. Gatuni declined all of these offers. Turned himself in. On April 13th, 2024, Kearney publicly announced on YouTube, episode 654, that Medfield police were investigating him for rape, calling it a lie. This was the first public mention of the allegation initiated by Kearney himself. On August 8th, 2024, an individual using the alias Haley Walbrand, Turtle Boy made him release him, so we're not going to talk about this. Pointless, you know? I want to get to, hang on. Oh, on August 10th, 2024, Kearney admitted on YouTube that he provided the report to Haley for posting. Statements that things that she says, like he, slammed her up against the fridge. Gatuni only went public to counter Kearney's lies about her as a fake victim after he disclosed the allegation and spread the report and out of context cropped text that contained sexually explicit messages. Kearney's actions, including the assault, threats, public disclosures, false accusations, and harassment campaign were intentional, extreme, and outrageous, causing Gatuni severe emotional distress, fear for her safety, and harm to her reputation and privacy. All false statements by Kearney were made with actual malice, knowing their falsity, like they're false, or with a reckless disregard. The sexual assault investigation, based on Gatuni's reports to law enforcement, remains active to this day, as confirmed by Medfield police as recently as January 2026. Gatuni was denied a copy of her own report due to the open investigation. Hold on. This attachment. I fucking phone. Basically, like he raped her. and like I'll die on that hill. She was definitely not, she was impaired. That much I do know. I'm gonna end this one, and I might do a live in a couple of days or whatever, but I just want to get the truth out, and I just want everybody to know that Karen is not gonna be held liable for statements that he made and he published. And that's that. And then the Lindsay Clancy case, sus. And just he's held to a higher standard. Like he has ethics he has to follow. He has like, morals, dignity. He has none of that. I'm just like disgusted at these people like trying to take somebody down. You know how many times people have tried to take me down? Never happened. Well, I'm gonna go. I have to catch up on some shows, and I will post another thing tomorrow, or I'll go live. I wanted to just talk about like some of the statements that he said and whatever, but then I have more just on route stuff I want to share with you guys. So I hope you guys like my content, and I think this is what people should be doing. Instead, look at them. Pathetic. That's absolutely pathetic. All right, you guys. You have a good night. Be nice to each other. And I'll talk to you later. Bye.